Is fraud a valid reason to contest a will? Have you ever wondered if fraud can be a reason to challenge a will? It is a question that many people face during the probate process. Let's break down what this means in the context of estate planning and opening probate. Fraud is indeed a valid reason to contest a will. In legal terms, fraud occurs when someone intentionally misrepresents important information to deceive the testator, who is the person that created the will. This deception can lead to an unfair advantage for the person committing the fraud. For example, if someone misleads the testator about the contents of the will or pressures them into signing it under false pretenses, that could be grounds for a contest. To successfully challenge a will based on fraud, the person contesting it must provide clear and convincing evidence. This means showing that the testator was deliberately deceived when they made or signed the will. The evidence must prove that the will does not reflect the true intentions of the testator. It is essential to demonstrate that the testator was misled or coerced into creating or changing the will in a specific way. It is important to note that fraud is different from forgery. Forgery involves creating a fake will or falsifying a signature. While both fraud and forgery can be grounds for contesting a will, fraud specifically focuses on intentional deception that affects the testator's decision-making process. In the probate process, wills are generally presumed valid until someone proves otherwise. This means that contesting a will based on fraud requires substantial proof. Courts are cautious about invalidating wills without strong evidence. The burden of proof lies with the person challenging the will to show that fraud occurred and that it impacted the will's validity. Fraud claims are particularly significant in elder law and estate law. Elderly or vulnerable testators may be more susceptible to deceptive practices. Protecting their true intentions is a key concern in estate planning and probate litigation. Attorneys in this field often emphasize the importance of careful documentation and clear communication. They may also suggest using additional legal tools, such as trusts or no-contest clauses, to prevent or address fraudulent interference. In summary, fraud involves intentional deception of the testator to gain an advantage through the will. It is a valid reason to contest a will, but it requires strong evidence that the testator was misled or coerced. Courts presume wills are valid, so proof must be clear and convincing. Fraud claims often overlap with concerns about undue influence and testamentary capacity, especially in elder law contexts. Legal guidance is essential to navigate these complex disputes effectively.